I'm Alex Sabo. I'm president of the Federalist Society, and Gianna Feinberg here is president of the American Constitution Society, and we're happy to present this Constitution Day Supreme Court panel here. We have great panelists here. The order of our presentations will be Professor Lash first, then Professor Walsh, Professor Chambers, and then Professor Campbell. They'll talk about some cases. They'll talk amongst each other a little bit and provide some thoughts and commentary, and then at the end we'll have, of course, questions and answers. So with that said, Professor Lash, thank you.
Putting this together on this Constitution Day, I'm glad to have an opportunity to get together with my colleagues and kind of go over some astonishing cases that were decided last term. We're obviously in the middle of an extraordinary constitutional drama regarding the replacement of a justice to the Supreme Court, and many aspects of that drama actually involve constitutional law. Not as much as I'd like, but many aspects of it. So we're not just looking back, but we're also looking forward, because the replacement of Justice Kennedy, of course, is going to have a major impact on the development of jurisprudence in the future. So without any further ado, I'm just going to talk about two cases, one from last term and one of this term, and then I think my colleagues are going to take you deep into theories of constitutional law. First up, both of the cases I want to talk about both have to do with the 14th Amendment and the substantive due process jurisprudence of the Supreme Court. Last term's case involves freedom of speech and religious exercise, and the case I'll discuss coming up has to do with the potential 14th Amendment right to be free from excessive fines. But first, the Masterpiece Cake Shop case. Okay. So one of the most highly anticipated and closely watched cases, obviously, from last term. In 2012, Charlie Craig and David Mullins went to Masterpiece Cake Shop and tried to order a cake to celebrate their upcoming same-sex wedding. Jack Phillips, the owner of the bakery, refused to make them a cake. Phillips, who describes himself as a cake artist, is also a Christian who closes his business on Sundays, refuses to design custom cakes that conflict with his religious beliefs. For example, cakes that contain alcohol or have Halloween themes or celebrate divorce or same-sex marriage. The Colorado agencies responsible for enforcing the state's anti-discrimination laws ruled that Phillips' refusal to provide a custom cake violated state laws and that he had no free speech right to turn down Craig and Mullins' request. An appeals court in Colorado also rejected Phillips' argument that forcing him to make a cake for same-sex couples would violate his right to free speech and to practice his religion freely. The state court upheld the commission's ruling that Phillips must create custom wedding cakes for same-sex couples and that he also must attend remedial anti-discrimination training and produce compliance reports. Phillips appealed to the Supreme Court of the United States. And at oral argument, another closely watched activity by the court, much of the justices' questioning involved whether a custom-made wedding cake should be considered as a constitutionally protected form of expression. They also asked about the degree to which a ruling in favor of the baker would undermine the enforcement of general civil rights laws. But the key moment in oral argument actually turned out to be when Justice Kennedy asked Colorado Solicitor General, the Solicitor General, about a statement made by a member of the Colorado Civil Rights Commission who had noted that religious beliefs had in the past been used to justify other forms of discrimination, like slavery and the Holocaust. And the commission member contended that it was, quote, one of the most despicable pieces of rhetoric that people can use their religion to hurt others, end quote. Kennedy asked the state Solicitor General if the court thought at least that member's comments by the commission had based his decision on hostility to religion, then could the judgment against Masterpiece stand? According to Kennedy, although tolerance is essential in a free society, Colorado, according to Kennedy, hadn't been very tolerant of Phillips' religious opinions. Kennedy's questions and comments at oral argument ultimately became the basis of the court's decision. In a 7-2 opinion, a majority of the Supreme Court ruled that the state of Colorado had in fact violated Phillips' 14th Amendment right not to be discriminated against on the basis of his religious beliefs. In his opinion, the now retired Justice Kennedy wrote that Phillips, quote, was entitled to a neutral decision maker who would give full and fair consideration to his religious objection as he sought to assert it in all of the circumstances in which this case was presented, considered, and decided. In this case, the comments by members of the Colorado Civil Rights Commission evidenced hostility towards Phillips' religious beliefs. Accordingly, the Commission's order must be set aside. Now, although the court ruled in favor of Phillips, that decision was quite narrow, and it avoided some of the more difficult issues in the case. For example, the court did not decide whether a custom-built cake should be a protected form of expression, or whether such forms of artistic expression are constitutionally immune from otherwise generally applicable non-discrimination laws. Those issues will have to wait for a future case where Commission members are not so vocal about their opinions. In the meantime, the same Colorado Commission is going after the same cake maker for pretty much the same reasons. On June 26, 2017, the same day that the Supreme Court agreed to take up the Masterpiece Cake Shop case, an attorney named Autumn Scardina contacted Phillips and asked him to create a cake designed pink on the inside and blue on the outside, which the attorney said was to celebrate a gender transition from male to female. Phillips declined the request because the custom cake would have expressed messages about sex and gender identity that conflicted with his religious beliefs. The attorney promptly filed a complaint with the same Colorado Civil Rights Division that had previously ruled against Phillips. And just 24 days after the Supreme Court released its decision in Masterpiece, the division issued a letter finding probable cause to believe that Masterpiece Cake Shop had again acted unlawfully in declining the attorney's cake request. This time, Phillips is suing the Colorado Civil Rights Commission. And I'm going to go out on a limb and say I think he's going to win for the same reasons that he won his first case. They will find evidence of official discriminatory animus against his religious beliefs. Or at the very least, that will be the crux of the analysis if it goes before the court again. The reason that'll be the crux of the analysis is because the current court limits its protection of free exercise to anti-discrimination norms. Now, this has been something of a dispute on the current Supreme Court, a dispute among members regarding whether or not free exercise of religion should protect more than just intentional discrimination, but that it also should generally protect the exercise of our beliefs unless the government has a compelling reason to prevent us from acting. As it stands, however, the court's free exercise jurisprudence depends upon the same substantive jurisprudence analysis that it uses in other cases, and it's an analysis when it comes to religious freedom that has no roots whatsoever in either the text or the history of the 14th Amendment. The court has made no effort to look at 14th Amendment period protections of free expression or free exercise of religion, or the establishment of religion for that matter. They haven't looked because they're focusing on the Due Process Clause, and there isn't a soul on the court that believes this is really a historical understanding of the Due Process Clause. No one believes that that's where your incorporated rights should be rooted. Everyone thinks it should be the Privileges or Immunities Clause, which actually has textual warrant and actually has a history at the time of Reconstruction. All of you who've taken constitutional law, though, know that the Privileges or Immunities Clause died in the slaughterhouse cases and in the Cruikshank case that came soon afterwards. And it was later on, during the Lochner period and the turn of the 20th century, that the court began to explore due process. Advocates have tried for years to get the court to move off of substantive due process and back into the actual text of the Constitution, privileges or immunities. They tried with the Second Amendment cases to get the court to take another look at privileges or immunities and thinking about incorporating the Second Amendment rights. But Justice Scalia and a majority of the court simply thought that that was an academic dreamer's game and could lead to no good result if the court opened up that box of, that Pandora's box or box of worms. Is that the right metaphor? I have to think about this. Can of worms, boxes, cans. However, there's another case before the Supreme Court this term that might actually have a chance of getting the court to move off of substantive due process and back to the actual text of the Constitution in determining the scope of your constitutional rights. And that takes me to Timms, of which I'll just say a couple of things. Timms against Indiana is going to be heard by the court this coming term, and it involves excessive fines and the prohibition against excessive fines in the Eighth Amendment. The court has never ruled that that particular provision in the Eighth Amendment is incorporated against the states by way of the 14th Amendment. Tyson Timms is an Indiana man who pleaded guilty to drug charges and received a 6-year sentence, 1 year in home detention and the remaining 5 on probation. The state ordered Timms also to forfeit his 2012 Land Rover, which he had purchased with the proceeds of his father's life insurance policy, on the ground that he had used the car to transport drugs. The state appeals court agreed with Timms that the Eighth Amendment bar on excessive fines applies to the states, and that the forfeiture of the Land Rover was unconstitutional because it was grossly disproportionate to Timms' offense. The Indiana Supreme Court reversed, however, emphasizing that the U.S. Supreme Court has never specifically incorporated the excessive fines clause against the states. This, then, will be an opportunity for the court to not only decide whether or not to complete its incorporation against the Bill of Rights against the states, but also to move away from the due process clause and tests like implicit in the concept of ordered liberty or the preferred freedoms doctrine or rights implicit in the American scheme of government, and instead investigate what exactly counts as a privilege or immunity of citizens of the United States. There's actually a history there. There's actual discussions at the time of the Privileges or Immunities Clause regarding excessive punishments against individuals, against discrimination and the impact of discrimination against American citizens, and against the rights of the freedmen to freely practice their religion. It's an opportunity for the court to actually go to the clause that matters and maybe bring just a sense of actual constitutional justification to its jurisprudence. I hope they take them up on it.
All right, well, I'll pick up right there and just point out, I'm going to try and get maybe 4 other cases on the table, but one thing, since I want to thank both the American Constitution Society and the Federalist Society for having this. The Timms case is really interesting because the issue that Professor Lash just mentioned is something that there's amicus briefs in favor of sort of reviving the Privileges and Immunities Clause for incorporation that have brought together the Institute for Justice, which is a libertarian organization, the NAACP Legal Defense Fund, the ACLU, the U.S. Chamber of Commerce, the Pacific Legal Foundation, Judicial Watch, the Brennan Center, and NYU. These are vastly disparate, ideologically committed organizations, and that just, I think, is helpful to point out that a lot of what we do in the law is sort of what are the rules for everybody, and sometimes you have a case like that comes along that brings people. I will say there was the opportunity to do this in the McDonald's case a few years ago, actually more than a few years ago, but that was the incorporation of the Second Amendment, and the historically oriented folks were disappointed then. So hopefully we're not back here next year with disappointment from Professor Lash. So 4 other cases just to put on the table kind of quickly. Minnesota's Voters Alliance versus Manske was an interesting First Amendment case. This also was not your typical 5-4 decision. It ended up being 7-2. The basic idea of this case was Minnesota had a law, or Minnesota law forbade wearing political things, political clothing in polling places. And the problem is, what is political? So if you're interested in oral arguments, go back and listen to that oral argument, because that was a case where oral argument unraveled the state's case completely, right? So you start with, how about the "Don't Tread on Me" sign that you sometimes see associated with is that political? Poor state lawyer, yes, right? How about the something advocating for the right to bear arms? Is that political? Yeah. Well, how about the text of the Second Amendment? Uh-oh. What about the text of the First Amendment? And so the holding was that the state had defined certain prohibited, essentially, speech, right, by content, and it was too vague ultimately to enforce. And it could have gone 5-4 if they had gone harder core on strict scrutiny of content-based prohibitions of speech, but it's really more or less a vagueness case, I think, is a good way to think about it. Trump versus Hawaii was a kind of like Masterpiece in that it could have been a much bigger First Amendment case than it was. This was the ban on travel from 8 different majority Muslim countries, later reduced to 5, and we'll skip all of the procedures and everything that went into it, but the short of it is that a 5-justice majority in an opinion written for the court by Chief Justice Roberts essentially said, we're going to apply a pretty low level of scrutiny to this executive order. We're not going to get behind into subjective motivations. We're not going to look at words that were uttered on the campaign trail or even while in office. But if you read it, it reads very much like a separation of powers where the judiciary is ratcheting down its standard of review. And what I thought is interesting about this case, apart from the doctrinal pieces and all of it, is what the dissents revealed about differing strategies of the more liberal justices on the court with a 5-justice, more conservative majority in certain things. And so there were 4 dissenters, but the 2 opinions really read quite differently. One of them, which was by Justice Breyer, joined by Justice Kagan, go ahead and read it and see. My sense is it reads like an attempt to kind of peel off a vote from the majority on a fairly narrow ground and send it back down and defer a lot of the hard questions for later on. And then contrast that with Justice Sotomayor's dissent, joined by Justice Ginsburg, which is a lot more forceful, focuses on the Establishment Clause. And there is an interesting clash between Justice Sotomayor and Chief Justice Roberts over Korematsu. And I just thought I'd read you some of the key passages. So Korematsu is the case involving exclusion of Japanese Americans, right, from mostly from coastal areas, but internment, right, based on race. It's the source of the idea that racial classifications get strict scrutiny, but of course it was upheld. Here's what Justice Sotomayor wrote, okay, and remember I said they didn't go into the subjective kind of thinking of the president. She's responding to this. She says, by blindly accepting the government's misguided invitation to sanction a discriminatory policy motivated by animus, all in the name of a superficial claim of national security, the court redeploys the same dangerous logic underlying Korematsu. Chief Justice Roberts described the invocation of Korematsu as wholly inapt. He made an interesting move that you don't see very much. They didn't sort of formally overrule it. He said that it had been overruled by the court of history, which makes me a little concerned. I just want to know what is federal law. But here's what he said on the merits. He said, the forcible relocation of U.S. citizens to concentration camps solely and explicitly on the basis of race is objectively unlawful and outside the scope of presidential authority. Korematsu, he said, was entirely unlike the, quote, facially neutral policy denying certain foreign nationals the privilege of admission. Okay, so we've got Manske, we've got Hawaii versus Trump. The last 2 cases I want to just put on the table are a case called Nifflas versus Becerra and a case called Janus versus a union with a very long name. And so the Nifflas case, which stands for, here's their long name, the National Institute of Family and Life Advocates. This was a case about a California law that imposed certain requirements on pro-life pregnancy resource centers. So these are centers that offer different services, but they don't refer or provide abortions. They don't refer for or provide abortions. So one of the rules said if you're a state licensed center, okay, there's a distinction between state licensed and not licensed. If you're a state licensed center, you have to essentially put a notice out about the availability of abortions elsewhere, including funding for it. And if you're not licensed, you have to put a notification prominently and in several languages. So in Los Angeles, it had to be in 13 different languages just because it was population-based, that we're not licensed, right? I'm paraphrasing, but you get the sense. So you single out a certain set of actors and you say, here are certain things you have to say. This was challenged based on compelled speech doctrine, and a 5-4 decision with Justice Thomas writing for the court. He held these unconstitutional. The court held them unconstitutional. Compelling, content-specific messages triggered strict scrutiny. Strict scrutiny wasn't satisfied. I'm leaving out a lot of details, but I'm moving on to the next case. Janus versus, and I'll give you the long name in the interest of equality with the National Institute, American Federation of State, County, and Municipal Employees, right? So that's information because this is about public sector unions and the way that they're funded. In a case from the 1970s called Abood, the Supreme Court had upheld against First Amendment challenge a system of funding by which you can extract, even from non-members, okay, certain operating costs for the union. And they distinguished between two different kinds of expenditures, and the ones that they upheld were fair share things. So the union, which is representing everybody that it represents, even if you're not a member, so it's still benefiting you is the rationale. So you ought to be able to be forced to pay for the kind of the benefits you're getting, the representation. But you can't be forced to pay for political and other kinds of advocacy. Over time, the courts have had difficulty policing that line. That's one of the reasons why Abood got overruled in Janus. There's others, but the bottom line is, in Janus, they overruled Abood and said, no, you can't, it violates the First Amendment to extract payments for this kind of, even for this kind of fair share representation. That's leaving out a lot of details, but I just want to get the case on the table. Nifflas and Janus go together as 5-4 cases. These are the typical 5-4 cases that you think of with our current divide on the court. In that respect, they're different from a case like Manske or even a case like Masterpiece Cake Shop. So I just wanted to get those out there, and we'll move on to the next.
Sure thing. So I can talk fast or I can talk slow. I think I'll probably try to talk in between, but only for 5 minutes regardless, because I want to hear what you all are thinking of. So part of what has taken up sort of my thought process about the court is less about the cases that are coming up, because the court has not taken nearly as many exciting voting rights style cases as it did last year, but thinking about what they did, or more importantly, what they didn't do. You know, a year ago when we did this forum, I was ready to talk about Gill versus Woodford and Manske versus Lamone and how they were going to decide this great partisan gerrymandering issue. And it was going to be electric. And it wasn't electric unless you are a civil procedure maven. Now, it's great if you are. There may be 2 or 3 of you out there. Show them the love, right? So it may be awesome to think about the civil procedure issue, but let me just talk a little bit about those 2 cases, what the court did do, what the court didn't do, and why it's important for watching what the court's going to do coming up. So we remember partisan gerrymandering, and the idea behind partisan gerrymandering. The idea is, look, if you control X number of the electorate, then you ought to probably get X percentage of the legislature, as a way of sort of thinking about that issue. We'll actually talk about that next month when I come back to talk a little bit about partisan gerrymandering a little bit more, but that's enough for you to know for right now. And the argument is that partisan gerrymandering itself is unconstitutional. Why? It's terribly unfair to take politics, stick it in the middle of redistricting, and to have folks try to gain an advantage through the districting process. That's terrible. But it's also politics. So the question that is out there, remains out there, because the court decided not to resolve it, is how unconstitutional is it, and under what circumstances can we fix it? Indeed, the suggestion has been made that it has been unconstitutional for years and years and years, but we just didn't quite know how to fix it. In fact, Justice Kennedy said, I don't know how to fix it. You tell me how to fix it, litigants, and maybe I'll fix it. So litigants came back and said, how about this? And he's like, boy, I don't think so. Okay. How about this? I'm not sure. Well, how about this? Not only am I not sure, I'm retiring. So as a consequence, we got Gill and Manske. So in a really small nutshell, what happened in Manske? Well, we had the Republican Party or folks from the Republican Party in Maryland complaining about the gerrymander in 2011 or complaining about the redistricting in 2011 that appeared to be a gerrymander. That was sort of one half of the case, and we're saying, hey, we can get a pro-Democratic Party gerrymandering case on one side, and then the other side was Woodford versus Gill, where the notion was that the Republican Party in Wisconsin had managed to district in a way that was anti-Democratic Party. Hey, we've got one case on both sides. The court took them both. Surely the court is ready to get the job done. So what did they do? Well, in Manske versus Lamone, they said, well, this involves a preliminary injunction against allowing the state to continue to use the districting plan that it's been using for the prior 6 years. And the court said, boy, we don't think that's a really good idea. We think you waited too long. We think you really can't get the remedy that you want in a reasonable amount of time. So no. And all the civil procedure folks said, amen. Well, they said, well, okay, fine. That was a strange case. We'll not quite sure why you took it, but okay, you took it and you dealt with it. But what about Woodford versus Gill? Woodford versus Gill was a situation where they said, well, we can't get rid of that one quite as easily, so instead we're going to talk about standing. We're going to get rid of it on standing. And again, the civil procedure folks said, this is so awesome. The Fed courts folks also said, this is grand. But how do they get rid of it? They say, well, look, the folks here are claiming that there's an injury to their right to vote. The right to vote is an individual right. It combines with other people's votes and rights to vote to make for the legislature. But if you are claiming that your individual right has been harmed, you can't then claim that the entire state map needs to be redrawn. You can claim that your district needs to be redrawn, maybe even districts surrounding yours, but not that the whole map can be withdrawn. So as a consequence, since you can only bring claims that you have standing to bring, that you have a right to say, this will fix my problem, they said, yeah, standing, no good, you're gone. So the case was sent down, and we'll see what happens during the next year or so. Now, why is this of particular import? Well, one, I'm just sort of dragging the court just for fun, because I actually think they did a perfectly reasonable job in those two cases for how they decided them, even though they're going to come back. But the reason why it's particularly important is because we're getting close to 2020, the new census, and the redistricting that will occur in 2021, which will be a mess, or a bloodbath, or both, as you wish. Why do I say that it may be a mess or a bloodbath? Because it's always a mess and a bloodbath. 2011 was, 2021 will be. Why do we care about it a couple years early? Simple. Because those folks who were elected in 2018, or in Virginia in 2019, or in 2020 will be the ones who determine how redistricting works. In Virginia, we will elect all members of the House of Delegates and the Virginia State Senate, 2019. Those will be the folks who will decide redistricting in 2021. So challenges to elections for 2019 are really, this is the last chance to get them through. And what will likely happen is a lot of stays, a lot of injunctions, a lot of issues will go up to the court. The court will have to decide them, and it will decide as much of the issue as it needs to. That being said, keep your eye out, even though the court hasn't taken cases that they know they're going to decide, keep your eyes out. Don't keep your eyes out. Keep your eye out for decisions that pop up, even ones that look procedural, because hidden in those procedural decisions may be doctrinal issues that the court wants to resolve moving forward. All right, I actually took 7 minutes. Sorry about that. We'll go ahead and leave it at that and open it up. Well, I'm sorry, we'll go to Jim.
Yeah, I'll just make
Professor
one
Campbell.
sort of final comment stepping back. And that is, you've heard from a couple folks that the cases this term are not nearly as sexy as the cases from the last term. And I think there's a reason for that, and it goes to an important point about lawyering that you guys should think about for the future. And the basic point is, you argue in front of the judges that you have, not the judges that you want. And I think that's a particularly important, not just for liberals, but also for conservatives to think about moving forward. So for liberals, I think this is a really important point. There is a sense of a sort of vindication of civil rights and progress through litigation. That can't be the operating assumption moving forward, and it's important to be realistic about sort of not just the sort of strategy in terms of what cases you bring, also the timing of those cases, who the litigants are, and so forth. So just 2 quick points on that. One is, one of the most important aspects of the litigation strategy for gay rights from the last 2 decades was keeping cases out of court. I think one of the most important things that civil rights lawyers were doing a decade ago was convincing people not to litigate gay marriage cases, right? And so it's very important when you're thinking about, as a lawyer, the strategy, there may, you may have to sacrifice certain things that you otherwise want because it actually harms the long-term goal. Second point on this is related to Kurt's discussion of Mr. Phillips. That's not the right case to bring. Just going back after the same Baker, trying to drum up a new controversy so that then you can relitigate a case that, with Justice Kennedy, they weren't willing to recognize the equality right in contravention of the free speech right, not the right strategy, right? And so, again, litigate in front of the court you have, not the court you want. For conservatives, this may seem like the court that you want. I think there are reasons to be skeptical that the court's going to move in particularly profound ways very quickly. And the basic reason is that I think recent events have especially highlighted a legitimacy gap for the court. So the court is in a really dangerous spot. It is suffering from the same sorts of perceptions of polarization that plague the entire rest of our polity right now. That's playing out in the confirmation process in profound ways. And then, of course, the recent allegations involving Judge Kavanaugh are just going to fuel a legitimacy gap if he is to be confirmed. And so I think that will be noted by people on the court, and that members of the court wanting to preserve the court's institutional status, wanting to preserve their ability to not just be impartial, but also have the appearance of impartiality. My guess is that this court, notwithstanding being the furthest right-wing court for quite a long time, assuming that a Trump appointee makes his way on or her way onto the court, my guess is that they move pretty cautiously. And that means if you're litigating for a conservative organization, you can't just assume you have 5 votes because you have 5 appointees. That's something that conservatives learned in a powerful way 3 decades ago when these same sorts of concerns were cropping up around abortion litigation. And of course, the Planned Parenthood case came out in a very unexpected way at that point. I don't have any predictions about abortion law in particular and how that sort of issue would play out. I just think the same sorts of thinking that lay behind the Planned Parenthood versus Casey decision will be at play on this court. And so I think we'll may actually find some sort of surprising reluctance by the court at times to embrace what we might otherwise expect. So let's go ahead and open up for questions. Does that make sense? Yeah. Good.
Was the 13th Amendment about involuntary servitude discussed at all in the brief? Because I listened to the oral arguments and they were mainly talking about the First Amendment. It's on. Okay, sweet. So the case, I think, has to deal with involuntary servitude, particularly because they're compelling production of a cake. Could you guys speak to why that would be or wouldn't be included in the brief or any arguments at all?
Yeah,
Sure.
you want to take it? Or
Good. Well, my first thought would be I would be surprised if it was in the briefs. I have to tell you, I haven't read all the briefs, so I'm not, someone else may know this. But since we're dealing with a condition for having a license, I don't anticipate a compelled servitude kind of case in the situation where all that would happen is that he would lose his license if he refused to actually take certain actions. In other words, he's not really required to make the cake or go to jail. It's simply make the cake or lose your license to practice this particular business. And ever since the time of the New Deal, and you can make, there were people I'm sure who did make 13th Amendment claims regarding government regulation and licensing requirements and stuff like that. But since he's not really being forced to take that action, it's simply a condition of him actually continuing to operate a business, I don't think 13th Amendment claims would come up. But that's just a brief, I don't know.
Yeah. I don't recall it being in the case, but you know, if you think back to just contracts, right, and how you can't get injunctive relief to enforce specific performance of a personal services contract, there's this kind of idea, right, and so this cashes out in remedies law, and so Professor Lash is exactly right in terms of the remedy that was sought and actually achieved was an agreement not to turn down future commissions of the same sort. And there was also some affirmative, and this is where First Amendment sometimes deals with the distinction between speech and conduct. So you have to train your employees, and you have to kind of undergo a certain type of training, and then not do something. And so the end result of a remedy like that for someone who won't go through and will continue with their refusals is to just you just don't operate your business. And this, by the way, is not just so in last week's talk about the transgender surgery mandate, this is a similar thing. This was in part what the doctors in the hospitals were talking about, which is the physicians won't actually be forced to perform procedures. They just won't be able to do their operations if they refuse to do a certain kind. So you see this in all different kinds of litigation. So it's a great question.
I'd like to follow up a little bit more in emphasizing why it's a great question. Although I feel comfortable in my legal analysis that I gave you, that what I did not say was the substantial body of literature from a variety of ideological perspectives that argues that we have underdeveloped the idea 13th Amendment rights, both potential in Section 2 in terms of government regulation, but also just the general idea of servitude and its application in the labor arena, that I think would have, and I think a lot of that scholarship and scholars, again, from a variety of perspectives, would have something to say about developing this idea of labor freedom that would call 13th Amendment issues into play. It simply has not been developed by the court. So although doctrinally I think I'm correct, in terms of theory, I think there would be a big crowd of people who would want to engage you in that conversation.
Oh no. Sorry. Okay, so we all love hypotheticals. So I have one. For the Masterpiece Cake Shop, what direction would the court's reasoning have had to move if he had discriminated based on race? I can't make a cake for you because you're black and my religion says so. Would that have had a different outcome, perhaps?
I'll take it. Well, I think there's a couple things. Number one, in terms of the actual rationale of decision, right, it would have been, it's interesting, right, because the Colorado, suppose you had the Colorado Civil Rights Commission that was condemning the belief structure, right? So let's just say that would not have been the ground of decision, right? Because it's perfectly expected, and this is actually what we want civil rights commissions to do, to condemn the belief systems, racist belief systems, right? So it would have had to be a different, it would have had to be a different rationale altogether. I think that the way the analysis would proceed would focus on a compelling interest, right? So again, when you have compelled speech, right, which was the sort of doctrinal box, right, that Phillips was relying on primarily. Free exercise, because of the Smith case, it was not a principal ground of decision. That wasn't the principal ground of argument. It was a compelled speech argument that he was making. And typically, the government can win compelled speech cases by satisfying strict scrutiny. And I think doctrinally, the argument for saying that you have a compelling interest and there's no other way to achieve this compelling interest is going to be easier to satisfy when it comes to racial discrimination. So I think that's that's the doctrinal analysis anyhow.
I think that's very hard because according to First Amendment law, you don't allow viewpoint-based compelling interests, and the basic argument you would have to make is that racism is so bad that it requires the eradication, even when of these particular manifestations of particular racist views, even when they conflict with employee speech rights, which, I mean, maybe that's what the court would say, but it's very awkward for the court to say that in light of current case law, which I think is why, that particular hypothetical was very challenging for the court. I mean, it's not surprising to me that they punted on this case because I think they're very difficult issues with ruling either way.
Stevie, could I ask you to clarify just for a second? What was refused in your hypothetical? Okay. I got it. Then it would be complete. My understanding would be a completely different case. I think for the same reasons. Right. That case, just to distinguish it from the masterpiece case, and it's a good hypothetical. It challenges us to think about the interplay between religious beliefs and civil rights.
Yeah, it's easy.
Oh, see,
Yeah.
okay, well, okay. Let me make one distinction, and then and you tell me whether or not this is where you want your hypothetical to go. Because I heard in your hypothetical that a person had been refused service on the basis of their race. And I think that's easily falling within the government's civil rights power for commerce reasons and all kinds of things like that. But what if, and it's very different from the masterpiece cake shop case, because he would make a cake for people regardless of their of who they were, right? He wouldn't make an artistic expression celebrating a particular marriage to which his religion disagreed with. So in your hypothetical, for example, say someone came and said, I would like you to make a cake celebrating racial equality. And the person says, no, I don't believe in racial equality. My religion does not believe in racial equality. If that were the situation, I think it would be exactly the same case, that this person was resisting the idea of being required to celebrate through artistic expression an idea for which they had ideological or religious disagreement. And that is the difficult issue that the court is eventually, I think, going to have to confront. If he faced a commission that said, I hate these damn religious people with their idiotic beliefs, and aren't we past that kind of stupid, I think he'd win. He'd win again, because however hateful you might find someone's religious belief regarding Jesus Christ or Muhammad or whatever it might be, sorry, you as the government don't get to make that call. So it's a question of you being able to decide what you artistically want to create in terms of a book or poetry or a mural, or whatever it's going to be. That's very different from a business person who says, I don't serve black people, right? It's not what you're asking me. I'm not being asked to express myself artistically in a way with which I disagree. I simply don't want to serve you because you're a veteran or because you're black or because you're gay, or whatever it's going to be. I think those cases are very easily taken care of in terms of government has power to control commerce and make you serve all comers. But what has not been decided is whether those cases where what you're being asked to do is not just serve someone, but actually speak an idea actually create an idea for which you have religious objections. That, I think, is a much harder case, and it's one that I would distinguish from your hypothetical.
Yeah, let me just add, just quickly, I don't think the court has made a serious run at a doctrinal distinction that would treat the two cases differently. They will say they have, but I just don't think they have. And frankly, I don't think the court has thought all that hard about the religion question at all, and whether someone's religion compels them to do something. They mouth the words, but they don't really get into that question. Instead, they try to run in the opposite direction and say, well, we can't determine what someone's religion makes them do without asking the same questions on that as a matter of fact as they would ask on any other matter of fact. But the notion of people being anti-interracial marriage, very similar in terms of how they get there as being anti other kinds of marriages. Not to say that I view them as being morally the same, but how they get there is relatively similar, and they can get there through their reading of whatever their scripture happens to be.
And just to add a couple things. The real action from going forward is in the clashing opinions of Kagan and Gorsuch in the Masterpiece Cake Shop case. So go read those, I think, to get a sense, because they're the ones, another piece of this, we focused on the, what a co-author and I called the imprudent on-the-record vituperations of the commission members. But another strand of the decision was the differential treatment of this guy named, I think his last name was Jack, who went and said, I want you to make a cake that says homosexuality is condemned by the Bible. I'm paraphrasing, but something like that. And those commissions were denied, and he complained to the Civil Rights Commission, and the Civil Rights Commission said, no, that's not the relevant kind of discrimination, no problem here. And Kagan and Gorsuch, and I forget who joined each of the opinions, but they drew different lessons from that course of activity as to whether that itself reflected viewpoint discrimination of the kind that Professor Campbell mentioned. And just so to maybe harmonize some of the anti-Fed courts procedural stuff that I'm getting from over here with the big picture pressures on the court, legitimacy, and all of that. That's why actually these federal courts doctrines and procedures are so important, because a lot of times that's where the kind of work gets done. So there was a very interesting question about the scope of Supreme Court review in Masterpiece Cake Shop. I actually thought that if they were going to punt, they would have done something like this. Now, what you need to know in order to understand this analysis is that the Supreme Court generally will defer to state court interpretations of state law. Its job is to speak about federal law. But there's, to my mind, a very serious question as to whether the activity that Phillips engaged in actually was discrimination on the basis of sexual orientation within the meaning of Colorado law. That is not, though, the Supreme Court's prerogative to answer, the Supreme Court of the United States. However, if their resolution of that question of state law is intertwined with errors of federal law, what the Supreme Court can do and say, no, you misunderstood Obergefell, you misunderstood Christian Legal Society versus Martinez, and because you relied on those mistakes in reaching your state law determination, you have to do it over again. That was another sort of avenue that was available to the court. But like I said, the real action is in the concurring opinions.
I agree.
Yeah. Sure.
Because I have established myself as a procedure nut, could y'all maybe talk about the direct, and what I mean direct is like the impact on the litigants of Minnesota Voters Alliance versus Manske? And like, because my understanding of it was a little bit weird that, well, basically there was a question as to whether or not it actually affected him as a person and what he was wearing. Could you kind of talk about the direct effects on the litigants, to the extent that you know?
I don't remember what T-shirt it was. I thought it had something to do with the Fourth Amendment. I can't remember, but there is this. I guess there wasn't going to be a real standing issue, in terms of as long as you have someone who will regularly be going to the polls and regularly be subject to this rule. There were some questions about how the state interpreted state law. And so, again, I gave you some of the hypos, the tough questions the state attorney had to answer. The dissenting justices in that case, Sotomayor wrote the dissent, and she basically said, you know what, there's enough uncertainty about how state law is being interpreted that rather than give it our own gloss, based just on this guy's course of action and then what the state attorneys have said, we should instead certify the question of the meaning of state law, give them a chance to make a narrowing, clarifying construction, and wait on the First Amendment until we have a clear thing. So not directly responsive to your question about the litigant, but that is, to me, the big procedure issue that came up in the case.
It was Tea Party logos and buttons saying, "Please ID me."
So I guess,
I mean, the only thing I would just add to that, to dovetail off of what Hank was saying earlier, is sometimes constitutional litigation focuses on the constitutionality of rules, not on the constitutionality of a particular course of conduct. And I think First Amendment law exemplifies that approach for the most part. And so when you're doing vagueness analysis or narrow tailoring analysis or something, we don't particularly care what any particular person was doing. What we care is whether the rule was constitutional, and it's exactly that sort of argument that the petitioners are trying to bring, and or maybe not petitioners, but the claimants in the gerrymandering case are trying to bring. Sometimes, as the gerrymandering cases reveal, the method of analysis the court uses doesn't look like that. It is more litigant focused.
Hi, my question concerns the legitimacy concerns that Professor Campbell raised, stare decisis and the Janus case. How did the court deal with the idea of overruling the Abood case and stare decisis? I know it's become particularly in public view with the Kavanaugh confirmation talking about the legitimacy of the court and upholding stare decisis. How did they deal with it in the Janus case, and do you think that they dealt with it correctly, and how do you think it should be dealt with in the future?
They dealt with it like spouses having a loud, angry argument. I mean, it was open hostility by the dissenters for what they thought was a usurpation of established First Amendment law, and the majority said, "Look, this is the best fit with current. Like this old case no longer fits with well-established First Amendment principles." I happen to think that both of those are true, and so this is a hard case because it revolves around a sort of long-standing precedent that over time, First Amendment law is all common law, right? First Amendment law is just gradual accretion of opinions over time that have changed and fundamentally changed, and the underlying theories of the First Amendment have changed over time. And so by the time you get to 2018? Was it just this past year, I guess? Mm-hmm. It no longer fit with the Abood line no longer fit with well-established doctrine. And so I think that's just the challenge of trying to figure out, what does precedent mean? Do we evaluate precedent at a sort of specific level of abstraction, or do we evaluate precedent sort of in conformity with a whole other set of jurisprudential principles? And that's why the case was hard, and that's why it was so bitterly contested.
In terms of litigation strategy, I think what went on, and again, not going to whether or not you're persuaded by it, but I think that they persuaded the court, and the court agreed that Abood was out of line with other lines of precedent. I mean, even though it goes back, I think, 1977 or whenever Abood was handed down, that it was treated as the outlier. And if you can make, just as a matter of litigation strategy, it is helpful to, if you're going to call on the court to overrule a case, convincing the court that that precedent is itself an outlier and in conflict with other long-standing doctrines, that allows them to maintain important lines of precedent and explain their decision as maintaining precedent and standing by a line of cases even while they overrule an outlier. And I'm trying to remember in reading the opinion, I think that's how they characterized Abood. But I know that was part of the argument before the court.
And it would have been overruled 2-3 years ago if Justice Scalia hadn't passed away. Just sort of as an interesting description about, of, you know, if we have an 8-justice court at the beginning of next year, this is an example of you know, some differences in outcomes. Speaking of outcomes, I suppose, should we?
Thank you.